The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. I'm Laura Flores Bachman, and with me is Amy Cheung. We're both senior legal counsel with ASISTA. And we are happy to have you with us today to talk about how you go about representing immigrants right now, immigrant survivors, I should say, during COVID. As you well know, things change seemingly by the minute. And so the agenda has shifted just slightly. We will cover a bit about yesterday's executive order that is going into effect today. Please bear with us if a couple of things have changed from the agenda. We still will cover all topics, but we're probably going to shift the amount of time that we give to the topics, just so we can make sure to cover everything else. As usual, the webinar is being recorded, and after the webinar, you will receive an email with the webinar recording. We usually have it within the week, so please be patient and we will get that to you. Your webinar materials today are in the Dropbox link that was sent to you earlier. That includes today's PowerPoint and materials that we will be referencing throughout today's presentation. If you have any questions during the webinar, please feel free to put them in the questions box of the GoToWebinar control panel, and we'll do our best to answer the questions there. Okay, I think that is all of housekeeping. So we'll go ahead and get started.
Did you want to let folks know about the CLE?
Oh, right. The CLE information. Today's webinar is being accredited for 2 CLE credits by the Texas State Bar. That application is pending, but as soon as we have the confirmed CLE credit, we will also include that in an email to you. I think that's it. Amy, anything else?
I don't think so. For the questions box, those questions goes directly to us and are not visible by other attendees. If there's anything that you wanted to share with all of the attendees, you can use the chat function, and there's a drop-down menu to select entire audience to share whatever you want to share with everybody if you're interested.
Okay.
And we already have a question. Is the PowerPoint available for taking notes on?
Yeah, so the PowerPoint is in a notes PDF, and it's in your Dropbox link. I'll ask Maria to include it in the questions, the control panel. Okay, let's go ahead and continue going. The agenda for today is to troubleshoot issues that are arising out of the COVID-19 pandemic, specifically related to survivor-based cases. So we'll identify available options and how to address the issues that are coming up in your cases. One more point on the Dropbox link. That Dropbox link was emailed to you today. So it was emailed to all registered participants. And I'll ask Maria to go ahead and include it here, the link again here in the control panel. Thank you. All right, so next slide, please. What we're going to start with is deadlines. I think that has been one of the issues that kind of seems to be overriding most of the difficulties in representing survivors right now. And reason being, obviously, it's difficult for you to get work done, I'm sure, being either virtual office, or if you're in your office, you probably don't have your normal staffing or the ability to meet with clients. So Because of that, meeting deadlines has become extremely difficult, and the deadlines are still in effect. And so what I mean by that is any deadline that you currently have for filing or for replying is still in effect, except for these specific instances that USCIS created in a brief policy. So initially, USCIS said for applicants or petitioners who receive an RFE, NOID, or notice of intent to revoke that is issued and dated between March 1st and May 1st of 2020, those responses may be submitted within 16 calendar days after the response date that was included in your notice, right? So essentially, you're getting an additional 59 calendar days from the date that you were given to submit your response. And the reason I say 59 is because it says in 60 calendar days. And so to be on the safe side within that would be the 59 days. I have to add just a huge asterisk to all of this. And what that is that the policy that USCIS came up with is not as tightly written, I'll say, as perhaps we would expect it to be. And so there's a lot of words in the notice that you know, Amy and I and the rest of the staff at ASISTA went back and forth on, like, what did they mean by this? What did they mean by that? So this is what what we came up with, right? Is that because it says within 60 calendar days, it's best to make it that they receive it on the 59th calendar day from the date that they gave you on the notice. Okay. Who's left out of this? Any RFEs, NOIDs, and notices of intent to revoke that were issued before March 1st. So even if you received it after March 1st, if it was dated before March 1st, dated and issued as the notice said, if it was dated before March 1st, then the exception and the flexibility, so those additional within 60 calendar days, does not apply. It also doesn't apply even if your deadline is before May 1st. So during this time frame that they have recognized is a time of national emergency, even if your deadline is within that time frame, it was left out of the policy. Now, ASISTA, as you know, if you're on our alerts, on our email alerts, we have sent a letter to USCIS officials asking for, number one, clarification, but number two, also a broader interpretation for survivors, given survivors' unique position. I've included those letters just in case you wanted to look at them in the Dropbox, so you can take a look at the letters that we have sent. Next slide, please. I'm going to do a quick just so we move on. And the poll is between March 1st and May 1st. My clients have had difficulty obtaining evidence needed to respond to a fee, annoyed, or notice of intent to revoke. Let me go ahead and start that poll. And if you guys can just answer yes or no. We're trying to get a sense of really on the ground, is it affecting people? And so if you can go ahead and answer that. I'm going to leave it up for a couple of seconds. The reason we're asking as well is we know that there are different levels of stay-at-home orders in various states, in various cities or counties. There are just different levels in place. And so it may be that in some locations, perhaps you can operate in business as usual, or at least not have too much of an interruption. All right, I'm going to close that poll. And okay, 72% of you do have clients who have had difficulty obtaining evidence between March 1st and May 1st. And this is specifically to respond to an RFE, NOID, or notice of intent to revoke. We know they've had other difficulties in other arenas, but this is helpful to know because it also helps us as we advocate with USCIS to let them know that, you know, well more than the majority of clients in a poll that we just took with all 200 of our members, you know, almost 75% of their clients are having difficulty to obtain documentation during these times. Why is it important? Is that this time frame is the time frame that people are responding to these notices, whether they were issued before or after March. And we don't believe that USCIS has, as of yet, recognized these very difficult circumstances that they're putting survivors in. And we know that there is a pending litigation lawsuit against USCIS, specifically relating to deadlines, et cetera, as far as, and in addition, other issues. So we may see additional policy changes or flexibility, but that's where we are now. So because that's where we are now, what do we do? How do we respond, right? So let's get into that with a hypothetical. Next slide, please. All right, you have an RFE that was issued before March 1st. What the RFE requested was a new law enforcement certification for your U visa. And the reason they requested the new law enforcement certification was because it didn't include the statutory citation for the qualifying crime, right? So that's the only reason. Assume everything else in that LEA was fine. And then the second thing that was requested is copies of all pages of petitioner's passport or an I-192 waiver. The deadline that you were given is May 8th. So the practitioner requested a new LEA, but the LEA has not responded and likely won't respond before the RFE is due. Copy of the passport was previously submitted. Hard copy of the submission is in the office paper file, and the client has lost her passport since that time. So what are the issues that we see just in this hypothetical? And Amy, you can play along with me on this one. I think that this hypothetical has come directly from technical assistance requests that we've received. Copies of the passports not available because they're in the hard copy in your office and you're not allowed by your employer to go into your office building, or you're sheltering in place and cannot even leave your home because of you know, your city, county, or state ordinance. The client has lost the passport, and even if she had the passport, has no contact with you because she's sheltering in place with the abuser. Those are all examples of, or iterations of, issues that we've seen with this seemingly, you know, easy RFE to respond to, right? In a normal day, in a normal time, you could probably get the passport copies back to USCIS pretty reasonably and in time. And you could probably get an LEA certification in jurisdictions where the certifying officers are you know, have good communication with you, or at the very least, an amendment to the original LEA certification, right? But right now, times are different. So what can we do in this situation? if you want to use the chat in the control panel, feel free to include any ideas that we don't come up with or that we don't mention. So you can use that in the chat box, where you will also see the link to the Dropbox. Feel free to go in there. But so a couple of things. First of all, reply, right? Since this particular RFE was issued before March 1st, it's not included in that USCIS extension for this emergency period, right? So because it's not included, reply by the May 8th deadline. You don't have everything that you need, it doesn't matter. Still submit a response. In your response, indicate what you are including. In this case, you can either say, copy of the passport was previously submitted. Unfortunately, you know, why you can't access it and why you can't include another copy here, but that you will include a copy as soon as you have access to your file, right? Or if you're able to get a statement from your client, that indicates she submitted a prior copy of the passport. She has since lost that passport and therefore cannot produce that passport. So replying is extremely important. In addition to your reply, included in your cover letter, you're also going to include whatever evidence you do have, right? So your own cover letter is not evidence. So if you need your client to tell USCIS something, right, you need to get a declaration from that client. We'll talk later about signatures. If you want to say that in your area you're forced to shelter in place, that your statement alone in your cover letter is not enough, include a copy of your area's shelter in place order by your governor, by your city, by your county, whatever is preventing you from access. Don't assume that USCIS has access to any of this, and don't assume that USCIS will know what your particular client's situation is. In addition, if your client lives in a different area from you, include that as well. If your client is, let's say she is sheltering in place with her abuser, and you're not able to get her statement, Amy, do you have a suggestion on what the attorney can do to let USCIS know that outside of the cover letter?
I mean, an attorney affidavit would theoretically also be an option in a case where you were not able to get a statement from the client at all. I think the issue in responding like this is that, you know, as the attorney, you still have to have your client's permission to submit things on their behalf, right? And so anything, if you were not able to get any kind of statement from the client herself to submit with this response, you could theoretically submit an attorney affidavit regarding this conversation that you had with your client, that she was not able to, you know, have any more intensive conversations or submit a statement or anything like that because of the specific danger that she faces at this time, and that you'll supplement as soon as possible. But you would have to have some kind of communication with your client to give you permission to do that in the first place.
Right. So that's a good point. So either if you do have a phone call, for example, try to get at least verbal communication, confirmation from your client that he or she gives you permission to respond on their behalf, or go back and review your your engagement letter or your retainer agreement, your contract for services, right? Whatever you guys call it in your office. Usually there is in there, and not always, and maybe this is the time to consider what you do include or don't include there. But obviously you always have a responsibility to act on your client's best interest, right? Maybe you want to state that in your contract from the get-go, so that if you do have a situation like this, you can use that general authorization to act in her best interest, and determine whether submitting an attorney affidavit would be in her best interest, right? So consider, if you don't have something like that in your contract, consider, what you would be comfortable including, and whether it would be helpful. I know that there's a lot of talk going on right now about how do we, what policies and procedures we put in place in our own offices to make sure that we are ready if and when something like this happens again. So it's a little practice pointer, and I do think generally, if you have your client's permission, that an attorney affidavit may be very helpful in this situation. Okay, so that's number one.
The suggestions that came up in the chat box is that
Yeah.
with respect to getting a new or amended search, that if law enforcement has published restrictions on their services due to the pandemic, for example, on their website, you could print that out and include that in the RFE response to document that it's law enforcement that is not able to accommodate those requests at this time.
Absolutely, yes. And that's what I was getting to next. So that's an awesome practice pointer. And yeah, that's exactly what you would do. Whatever is impeding you from being able to obtain the law enforcement certification, new certification or amended certification, or any other information from the officer, yeah, print up if they have something on their website, particularly if there's something specific about U visa certifications. Otherwise, the other possibility, and I know some of you have used this as well, is you email the certifying officer and get an out of office response, right? Or get an automatic response that says, we have put a hold on U visa certifications. I know in some jurisdictions, people are getting that response back. Print it up, included with your filing. If there is a date included with the law enforcement organization's notice that says when they're going to be reopened or when you might get it, well, then point that out. And then obviously you don't want to give yourself that deadline. So you just say within a reasonable amount of time after the LEA reopens. You're in all of this, you're trying to get one of two things. Either one, that you are able to show that what they have in their record already satisfies approving the I-918, or in the alternative, you're trying to get more time to respond. So if you're trying to get more time to respond, state that in your letters, right? So I'm going to apply within a reasonable amount of time, as soon as I can get A, B, and C. This is what's preventing me from getting A, B, and C. Evidence attached that I've been prevented from getting it. And based on all of this, I'm requesting an additional whatever, right? 90 days from a certain date, 120 days, whatever you think is reasonable. I say give them what you think is reasonable, because they can always decide, 1, not to extend, 2, to extend and give you a different date, or 3, to you. So you may as well, give them what you think would be appropriate given the circumstances in your particular client's situation. And then the final thing I'll say on this is, because one of the things that you're hoping they can do is approve based on the evidence already in the record, or with the limited evidence that you're including in your response, always go back and do a full review of the application, of your evidence, and see whether, maybe USCIS is incorrect. Maybe they do have all passport pictures, passport pages. Maybe they do have the LEA did include the statutory citation, but perhaps included it in a different box or something. Don't assume that well, and you all already know this, but I'll just state the obvious, right? Don't assume that what USCIS is requesting isn't already in there, or that you didn't already provide it. And if you have, point that out as well, and ask them, if you're confident that it's all in the record, you can ask them to make a determination based on the evidence. In other words, make a decision based on the merits rather than if they try and make a decision saying you did not adequately respond, they can claim that they are denying based on abandonment. And why is that important, that they not deny based on abandonment? The reason that's important is that it could limit your client's ability to file an I-290B appeal as opposed to an I-290B motion to reopen. If you look at the regulations, the I-290B cannot be filed as an appeal if your petition or application was abandoned or USCIS determines that it's abandoned. Obviously, if it was not abandoned, you can file an appeal and make the argument that you do have the ability to file the appeal because you did not in fact abandon. But in order to avoid all of that and just ask for it right up front in your response if that's what you're wanting them to do, so that you have full access to appeal, motion to reopen, motion to reconsider. Okay, let's see. Are there any questions on this?
Not on this specific topic.
Okay,
just so folks know, I'm seeing that folks are submitting questions about other issues. We're going to try to get to as many questions as we can. If we are not able to make it to your question, please send us a TA request and we're happy to work it through with you individually.
Thank you. Okay, so next slide. We included here just kind of setting out exactly what your what the implications are of COVID-19 for responses, right? We already talked about attorneys not being able to go, or representatives not being able to go to their offices, clients not being able to get in touch with their attorney or representative. Consular office from client's home country is only open for emergencies, and we'll talk a little bit about consular processing later. No one can obtain documents, et cetera, et cetera. So the DHS effects has also been affected, right? We know that Vermont Service Center has temporarily suspended the phone hotline. It's currently unstaffed. So calling the phone hotline right now, even if you leave a message, you'll probably not get a call back. I know that we have had those, random cases where someone will get a call back from Vermont Service Center, but their official statement is that it is temporarily unstaffed, so don't rely on that. The email hotlines may be slower to respond, but the email hotlines are still in effect. So if there's a reason why you need to get in touch with the hotlines, do still try and send it via email. It's always a good practice to send it by email anyway, because at least you have a paper trail or an electronic trail of what you've sent to USCIS and when you sent it. Okay, next slide, please. We've covered this, but it's good to have it in writing. I don't think there's anything else in this one. Okay, so yeah, sorry, I covered this with the hypothetical. So respond timely, let them know what you don't have, and make sure you have evidence and not just your statement. Okay. We also talk about explaining how previously submitted evidence meets the eligibility requirement, and including what amount of time you need to respond. The last point here on this slide is important. There is one exception or potential flexibility that applies to all responses to RFPs, NOIDs, and notices of intent to revoke. And that is the special situation flexibility allowed by USCIS. And that is on this link that's included in the PowerPoint, but it's also in your materials in the Dropbox. I just went ahead and turned it into a PDF so you could take a look at it. It does require showing a nexus between the special circumstance and your inability to respond. So that is why it's so important to make that that personal assessment of why your client in particular cannot respond. Saying that there's a national emergency will not be enough. Saying that there is a worldwide pandemic will not be, and the reason it will not be enough is because USCIS's twofold. USCIS's exception is limited, right? And if you're outside of that box, then they're essentially telling you that if you're outside of that box, the national emergency isn't going to be enough of an excuse unless it fits into these special circumstance flexibility. I will note one thing. This particular policy, the special circumstances policy, has actually been in effect since October of 2019. Why is that important? It's important because in thinking about this, if there are other reasons why your client cannot submit a response, include those as well, right? Special situation doesn't have to be limited to COVID-19. So if you have COVID-19 and that's directly tied, great. If there is another reason, for example, your client lives in a domestic violence shelter and has no personal transportation, right? That might have been a situation that existed before COVID-19, but it's directly tied to her ability to be able to get documentation. So include that as well, right? You want to include all special situations that may be directly tied to your client's inability to present the documentation on time. Okay, next slide, please. So there was also flexibility provided by USCIS on I-290B deadlines, right? So USCIS will consider certain I-290B forms USCIS will consider certain I-290Bs it receives up to 60 days from the date of the decision before it takes any action. So this particular flexibility in the deadline is different. Instead of adding 60 days to the end of your current deadline, it is a whole new deadline, right? And so if it's normally 33 days from the date on the letter, it's now going to be 60 days from the decision date, right? So we're not doubling up. We're not doing 33 plus 60. It's just going to be 60, okay? So that's the first thing. The second thing, the language in this policy was also a little interesting. And it says I-290Bs from an appealable decision with AAO jurisdiction issued and dated between March 1st and May 1st, inclusive. So the dates are the same, right? So dated and issued March 1st to May 1st, but this from an appealable decision with AAO jurisdiction, that was the tricky part, right? Does it relate only to I-290B appeals, or does it relate to I-290B motions to reopen where it could have been appealed, right? The language is a little bit quirky. I don't want to, there's no hard and fast rule, right? If you need to file an I-290B motion to reopen, you need to just get it filed, right? If you need to rely on this extension, then make your arguments that your I-290B was within this extension. If you're looking at it, so in other words, if you have no other choice, do it, right? Use this extension and make your arguments why yours falls into it. But if you wanted to be uber conservative, it seems like they're limiting the type of I-290Bs which are included in the 60-day extension. So that is important for you to review each and every individual case to determine, what type of I-290B are you filing, to determine whether the underlying application could have been appealed, and whether you need to make an additional argument that they need to accept your particular I-290B, even if it's a motion to reopen, and why in that 60 calendar day. In the alternative, always, if you're not sure whether your I-290B is included, go ahead and make that special circumstances argument, right? They can have flexibility if they want to, and the fact that they issued even this flexibility proves that they can have flexibility, right? So don't decide not to file, even if you think it may not fit squarely on this policy, because the policy is not super well written. So I think there are arguments to be made. What about I-290Bs that are due between March 1st and May 1st that were not issued between March 1st and May 1st? Those have the regular deadline and should be submitted in accordance with the regular deadline. If the type of I-290B that you're submitting requires that a brief or other documentation be submitted together with the I-290B filing, ask for an extension of that, right? So file your I-290B, but ask them to apply their special circumstances rule in accepting additional or supplementary brief or evidence to support that I-290B. I think given that special circumstances flexibility is so broad, I think using it and tying it to the COVID-19 is important. The other reason we need to do this is because we need to push back, okay? We need to push back against USCIS's determination that March 1st to May 1st was enough, because those decisions and those deadlines, it's not enough that only those are covered, particularly for survivor cases. So make that argument and continue filing, even if you're asking for flexibility outside of their specific stated policy. I will also say that we have included the practice pointer, our practice pointer from the beginning of April on this extension and deadline. So that might have just a little bit more additional information and examples that you may be able to use. It's in the Dropbox. Okay, I am going to move us along to initial applications and initial evidence and how that's being affected by COVID-19. And I'll turn it over to Amy. Next slide, please.
Thanks, Laura. So obviously, in the same way, or in much the same way that your clients are affected by COVID in terms of their ability to respond timely and completely to RFEs and NOIDs, many of those same problems arise in the context of filing initial applications. And so we're going to be talking about a few of the issues that we've been hearing about from you guys, as well as some of USCIS's responses, and of course, the areas in which they have really not made any accommodations at all, and some strategies that you might be able to use in your cases. So when we're talking about initial filings, the real problem that we have is that USCIS has not changed any of the filing deadlines when it comes to initial submissions. So this means that, for example, self-petitioners, spousal self-petitioners who are divorced from their abuser or whose abuser has died still need to file the I-360 within 2 years. Child self-petitioners who are filing must file before they turn 21, or if they're filing based on the exception, they still have to file before they're 25. Also, U visa holders or U non-immigrants still have to file their adjustment of status before their U non-immigrant status expires, right? So all of these statutory filing deadlines that we had before remain. Likewise, regulatory deadlines like the 6-month expiration for law enforcement certs, likewise, age outs. So for example, any derivatives who are turning 21, or in the case of U's and T's, if you have a principal who's turning 21 who would have wanted to include their parents or unmarried siblings, all of that needs to be included. All of that needs to be, those applications would need to be filed timely as usual. So we have requested to USCIS that they suspend filing deadlines and also that they automatically extend status for people who currently have it, such as for U's and T's. We haven't gotten any response from USCIS yet. If they do respond, we will certainly let you all know. But until they say otherwise, you have to assume that all filing deadlines apply except of course, for the ones that Laura mentioned earlier with the 290Bs. And for anybody who hasn't heard, AILA has filed a complaint regarding USCIS's failure to suspend deadlines and extend status. And so there's a copy of that complaint in your Dropbox materials. They're also looking for plaintiffs who have been affected by USCIS's refusal to accommodate, to make accommodations for these deadlines. So if you have clients who are being affected, get in touch with AILA and let them know because it could be potentially be helpful for that suit. Next slide, please. Okay. All right, so another issue that's been coming up with initial filings is what to do about signatures. So obviously forms need to be signed. If you're submitting a statement, the statement needs to be signed. So what do you do about signatures when you can't meet with your client? So USCIS has stated, and their statement about this is in your materials as well, that an electronic reproduction of a wet signature is okay, even in cases where normally they would require an original signature. So what this means is that, let's say you have a client that you can't meet with in person, but you can either email or send them the completed form and they can sign it. And they have some way to get you an electronic reproduction of it, whether it is a fax or a scan or potentially even a very clear photograph. Photocopies are okay, although I'm not sure why you would be able to get a photocopy where you weren't able to get the original. But if that's the case, that would be okay to submit. USCIS recommends that you do keep the original signature page because they could theoretically ask for it at a later date, right? So just keep that around for your records. A couple of the questions that we've gotten have been, well, what about electronically produced or digital signatures, such as what you would get through a software program such as DocuSign? USCIS has not said that that's okay. This is in contrast to EOIR, which has said that digital signatures can be okay, but USCIS hasn't said this. And so because USCIS hasn't said that it's okay, we would recommend that you not do that if at all avoidable. Another question that we've gotten is whether or not it's okay to have the client sign a blank piece of paper and send you a copy or a photo, a scan of that signature that you then copy and paste into the document that needs to be signed. USCIS has also not said that that's okay. And so in the interest of being cautious, we would recommend avoiding that as well, where at all possible. And we're going to be talking about where that's just not avoidable and you know, how to document that as well. A lot of it's going to be the same as what Laura talked about earlier in terms of how you respond to RFEs where you're just not able to get what you would normally want to get. But that is what USCIS has said about signatures. So your number one option is going to be to get an original signature, just like you've always done. Your number two would be get a signature on the form, but you know, a scan of it or a fax of it is okay. And then beyond that, I think there are some risks in these other options that theoretically should be available, but which USCIS has not said are. The other thing I would say is that if you are using like a photograph of a standalone signature from the client, you definitely want to document that you went through the entire document with the client, that your client knows what's in it, that your client gave you permission to do this, that your client wanted you to do this, and that you've advised your client that there is a risk that USCIS will not accept the signature and that in theory they could reject the application. Okay, next slide, please. Next up is biometrics. So for biometrics, it's fairly straightforward. All of the application support centers are currently closed. They're closed through May 3rd, but USCIS, it's possible that USCIS could extend that closure. And so obviously while the ASCs are closed, all biometrics appointments will be canceled. And so the ASCs will automatically reschedule these canceled appointments once they reopen. If the USCIS, and like as before, after the ASCs reopen, if your client can't attend their appointment, at that point you would have to request a reschedule, right? So that's business as usual there. Another note to point out for biometrics is that USCIS has said that if you have a pending 765 renewal, so for a renewal EAD, they will go ahead and process that even if your client is not able to provide new biometrics. And what they'll do is they'll use the previously provided biometrics that are already in the file. Out of curiosity, has anybody gotten a notice from an ASC saying, or USCIS saying that they will go ahead and process another type of pending form using old biometrics? You can just respond either in the chat box or in the question box. Okay, we've gotten a couple yeses here, yeah. So it does seem that in some cases, USCIS, where they have previously submitted biometrics, that they'll just go ahead and process the application regardless of whether it's a 765. But it's not clear how consistent or universal that is going to be. But we've gotten a whole bunch of yeses here about that. So it does seem like a lot of people are seeing this. One person says that she got it in the case of a T visa adjustment. So that's a bright spot here, a small bright spot. Next slide, please. Okay. So like for the application support centers, the local offices are also closed through at least May 3rd, but just keep an eye out to see if the offices decide to extend that closure. Like for ASCs, if USCIS cancel the interview, they will reschedule that automatically for you. If your InfoPass appointment was canceled, they will not reschedule that automatically, so you need to go back in and reschedule that after the field office reopens. They've also said that obviously there are people who have emergency reasons to need a local office appointment during the office closure, and they are working, even though they're generally not open to the public. So in that case, you can contact the main USCIS contact center and ask them for an appointment. One issue that we've heard is that it could be problematic to get an appointment and communicate with the contact center if your client has a pending VAWA URT application, because in general, the contact center is not able to provide any information about cases that are covered under 8 U.S.C. 1367. So if that happens, the first thing I would say is ask for a tier 2 representative or ask for a supervisor, because it's possible that they would be better able to understand the exigency of the situation and to understand that they really need to give you an appointment. If that doesn't work, please submit a TA to us, reach out to us, and we'll see if there's anything that we can do. Obviously, we can't, make an appointment for you at the local field office, but we can certainly try to reach out to our contacts and see if there's anything that can be done in that situation. Okay. And next slide, please. All right. Passport photos. So passport photos are still required for certain types of applications, in particular the I-485 and the I-765. And so it's hard right now to get passport photos. We've heard that there are some photo centers that are still open. So depending on your state and what's going on and what people are and are not allowed to do, potentially it's an option for everybody's health and safety. It may be a safer option to see if your client can download or has a friend who can download a passport photo app on their cell phone that they could send to you. And if you had access to a photo printer, you could print it out yourself and do the passport photos that way. Medical exams. So we understand that it's very difficult to get medical exams right now. A lot of the doctor's offices aren't seeing patients. And so it is still required for adjustment of status. That hasn't changed. But medical exams are not required at the time of initial filing. And that's generally true. And so you can go ahead and file for the adjustment of status application and then wait for an RFE to submit the medical exam. And hopefully by that point, the civil surgeon's offices would have reopened and you would be able to get that medical exam. Okay. Is an inadmissibility waiver considered initial evidence? Well, yes, it is. So when it comes to required initial evidence, this is one of the times when you just do everything that you can to submit it on time and as required. But to the extent that you are not able to submit something that's required, that's where we would recommend doing the same things that Laura was talking about earlier, where you document and explain why you're not able to do certain things that would otherwise be required, why you can't get passport photos, why you can't get a signature in exactly the way that USCIS wants you to get a signature, but you're doing your best and this is the way that you've done it. Is there any guarantee that USCIS is going to be reasonable and accept that kind of explanation and proceed in the application and that you won't have problems? No, there's no guarantee. There's no guarantee about any of this. But I think we're all doing the best we can to represent our clients the best we can. I think especially in situations because USCIS has not extended any of the statutory or regulatory filing deadlines except for 290Bs, you still have to get these applications in timely and make the record the best you can so that your client has the best argument going forward for why USCIS either should have accepted the application as filed or should at least consider it timely filed and give you an opportunity to supplement. Next slide, please. Okay. So as I was talking about with required initial evidence, can you wait for an RFE? Well, I mean, you can, as I said, if you've got a deadline, file, right? File it, document the reasons why you can't submit the other evidence at the same time. The policy memo on RFEs saying that USCIS can deny an application that's missing required initial evidence without issuing an RFE still is in effect. The memo saying that they can issue an NTA after the denial of an application after the 290B period has expired is still in effect. So you can certainly do it. I think there's just this risk, right? There's this risk that the case could be denied without an RFE, that an NTA could be issued. So I do think it's important to advise your clients about the risk that this could happen, but what's their alternative, right? If you've got a deadline, if you've got an age out, what are you going to do instead?
Hey, Amy, really quickly, a couple of attorneys wanted to know, can you repeat whether an inadmissibility waiver is required evidence? I think the sound might have gone out briefly.
Oh, sure. Sorry about that. So inadmissibility waivers are required initial evidence for people who are inadmissible for the U visa as well as for 485s. You can see the list, the checklist of required initial evidence at uscis.gov. We would caution you that those lists are not the end all and be all of what is required initial evidence, but they do tell you that USCIS considers inadmissibility waivers to be required for those types of applications. That said, I think there are lots of situations where there's room for debate about whether or not the client is inadmissible or about whether a particular inadmissibility ground applies, right? And so I don't think, like, we're not saying that you should submit an inadmissibility waiver where you don't think the client is inadmissible. It's that if the client needs an inadmissibility waiver, that is generally considered required initial evidence.
Great. Thank you for including that, because I think a couple of people were confused as to whether the inadmissibility waiver did have to be included. So that's great. Thank you.
Okay, so what else? Money orders. So fees are still required, obviously. So to the extent that your client is not eligible for a fee waiver, they still do need to pay their filing fees. It is potentially a bit more difficult these days to obtain money orders, and of course, many of our clients don't have access to checking accounts. And so some options are if your client can pay the office and if the office can cut a check on behalf of the client, that could be a workaround. Also, there are places where postal offices are still open and they issue money orders as well. So depending on your state, if folks are allowed to go to the postal office, assuming that your client isn't incurring too much risk, which is a significant assumption, I do realize, that's potentially an option as well. And obviously none of these workarounds are ideal, right? None of this is what we would actually want to have to do at this point, but we're stuck at this point where USCIS hasn't extended deadlines. We still have to file and we just have to do the best we can. And so we wanted to know if folks are seeing other issues with respect to initial filings. I am seeing a bunch of questions here, so I'm going to take a quick peek, but at the same time, if folks have experience that they want to share with other folks, please go ahead and put those in. Okay, so with respect to the 192s, I see one of the questions is that somebody was under the impression that 192s could be filed later for U visas, especially now that they're having a lot of applications rejected due to fee waiver denials. Is this not the case? So what we've been seeing in practice is that USCIS may reject a 192 for a U visa and still receipt in the 918. What we don't know is whether or not that practice is going to continue, because 192s are technically considered required initial evidence. And so it's not clear exactly where this policy is going to go in the future. But you are correct that we have seen that USCIS will reject the 192 but still receipt in the 918, even where the client is inadmissible. Okay, I'm just taking a quick peek here if there's anything else. Okay, somebody is saying that she's heard you can do online photos through the Costco website and they will mail them to you.
And then there is a question. Oh, sorry, go ahead.
Another person is saying that Walmart.com will do passport photos.
And then there is the question, someone is wondering whether anyone has actually received denial based on failure to include the I-192 as initial evidence.
I certainly have not seen one.
Yeah, no, neither. I think what we're all doing with this particular issue, specifically relating to I-192s, is managing risk. Do you want to risk that your client will be the one client that they decide to say, hey, we did say this was initial evidence and you didn't submit it, and our RFE NOID norm memo, policy memo specifically says we don't have to issue an RFE for initial evidence, so we go straight to denial, right? Do you want, I guess it's, do you want to risk that in your client's case? In some situations, like when, you know, there's the kickback of the I-192 for fee waiver denial, I mean, sometimes it's outside of your hands, right? But I think it's case by case, you're evaluating risk all the time. My general rule of thumb is, if you know definitively that a ground of inadmissibility applies, it's best if you can submit it with it, submit it with it. Submit it with the I-918, just to get rid of that particular risk that it'll be denied. If you feel like you may have evidence in the future to supplement, well then supplement, right? The cases are pending for quite some time, and there's nothing that prevents your ability from supplementing any application.
Okay. All right. So I think that concludes the section on initial evidence. Laura, did you want to cover the maintenance of status issues?
Yeah, why don't we move on to that? It's a short section, but we'll get to that. Yeah, Maria, if you can fast forward to the maintaining / extending status and work authorization. Yeah, there we go. So in addition to filing deadlines and everything else, we also need to think about maintaining and extending status and work authorization during this period where we have those same barriers to access to our clients and access to evidence as we do for filing applications or responding to deadlines. So let's talk a little bit about this. Next slide, please. Okay, so let's start off with the bad news. And the bad news is USCIS has not suspended our clients' requirement to maintain valid status, maintain a work permit in order to work, and have evidence of valid status on their person, right? There's a section in the INA that makes it some kind of offense. I can't remember if it's a misdemeanor offense for not proof of your status, right? Those obligations have not gone away. And so the first thing I will say is, if you can timely file an extension or a change of status, then do it, and follow all the practice pointers that Amy just went through in terms of initial filings and initial evidence. Obviously, that's not going to be possible in many cases, and so because the change of status, extension of status, and work permits are not automatically extended, and there's no suspension of the requirement, the only thing that USCIS did is, on April 13th, they made this announcement that said, oh, special announcement on extension of status and work authorization. And what they said is, we understand that during COVID, there is difficulty in maintaining status, in changing status, and in maintaining your work authorization. And then they went on to say, we're essentially not doing anything about it. You can apply the special circumstances guidance, the same one that we talked about earlier. It has a link to that. And that was their announcement. So they essentially said, look at our special circumstances and look at existing regulations relating to acceptance of extensions, changes outside of the filing deadline. So if you fail to timely file a request for an extension of status or a change of status or work authorization, you're gonna have to do the same thing that we talked about before in terms of special circumstances and show the nexus between the COVID-19, for example, and your client's inability to comply with filing on time. And the only thing USCIS indicated is they will take that into account. What does this really mean on the ground? Well, and actually, before we get to what it means on the ground, do remember that existing regulations for U and T visa holders does say that at any time, if they need to file an extension for U status or for T status, and they failed to file that extension timely, they can submit that application late and explain why they were unable to file on time. So there's, I pointed out that the U's and T's have a different regulation because there's a general regulation in the non-immigrant visas regs. So under 214.1, I believe it is, there's a general regulation that says if you fail to timely file, we can accept a late filing and nunc-pro-tunc to the date of expiration if we approve it, if you can show exceptional circumstances, and then it has a list of how you show exceptional circumstances. Know that that regulation doesn't apply to U's and T's because U's and T's have their own regulation on late filed extensions. So look at the regulations, look at the special circumstances link provided by USCIS, make your arguments, and remember to ask not just for an extension, but for an extension issued nunc-pro-tunc to the date of the initial expiration date, so that there's no gap in status. Okay. Now, going back to what does this actually mean on the ground? What it means on the ground is your client is probably, actually, can you all raise your hands and let me know if you can hear me? I've got a message here that we lost audio. Can you all hear me? Can you just raise your hand, your virtual hand? Amy, can you hear me?
I can hear you.
Okay, good. And I can hear you. All right. So you may want to check your individual audio in your audio tab of the GoToWebinar control panel. Mine shows that my audio is working, so hopefully everybody can hear me. But okay, so what it means on the ground in terms of USCIS not issuing, not automatically extending status, not automatically extending work authorizations, is that your client will be out of status until you do something about it. In other words, the onus is on your client, it's not on USCIS. And because we know that until USCIS actually picks up the file and looks at it, nothing in the system is going to change. And that means ICE could still theoretically pick up your client if your client is out of status, right? Theoretically, that is possible. So keep that in mind when you're assessing, should we file a late file extension? The answer is yes. If it's late, no matter how late it is, file it anyway, so that if there is the unfortunate circumstance of your client having contact with ICE, at the very least, you can show them two things. Number one, that you did file even though it was late filed. And number two, a printed copy of their special circumstances guidance. And if it's a U or T, a printed copy of the regulations and USCIS policy memos on extensions, on URT extensions, because those will all be helpful in showing ICE that your client actually did exactly what they were able to do, told to do in this circumstance. I'm hopeful that your client would not have contact with ICE, but it seems like the ICE machine is still operating during this time. So,
well, I mean, they have
yeah.
said that they're not going to be taking enforcement actions unless the person poses a security risk or is subject to mandatory detention, right? So in theory, they should be exercising more discretion at this point.
Yes, they have said that. You're absolutely right. And I know, Amy, you're going to get into a little bit more of that maybe in a few minutes.
Yeah.
So yes, in theory, they have said that. But because we can't rely on just theory, unfortunately, we rely on USCIS theory, right? we rely on USCIS theory and file what we can file, even if it's late filed. Okay, next slide, please. I know that that was a quick section, so if you have any additional questions, feel free to put them in the chat box. If you have, and if we have time at the end, we'll go back to maintenance and continuance of status. Change of status. Okay, we're going to get into consular processing and executive orders, and this, of course, has changed, is changing. But what we're going to start with is consular processing. So, in this hypothetical, U visa petition and derivative I-918A have both been approved. Great. The derivative is turning 21 on May 5th. So the derivative is turning 21 on May 5th. The derivative beneficiary already had an initial, they had an initial interview with the consular post, but the consular post did not make a decision. Instead, they said, you have to go get a medical exam. And so derivative is unable to get a medical exam because everything's closed. What additional information do you need to help the derivative to know if you can help them? Can you help them? I'm just curious to see what you guys think about this. If you have suggestions on this, if you have seen this or some version of this, put it in the chat box, because I'd like to know what you think other additional information would be helpful to know from the derivative. Okay, well, on my part, one thing I would want to know is, why did the officer ask for a medical exam to begin with, right? Is it possible that ground of inadmissibility, a medical ground of inadmissibility, number one, does not exist, or if it does exist, it was already waived? Is that possible? Oh, good. So someone's saying what they would, what Maria would ask is, did they keep your passport? Yeah, that's a good question too, right? And why would we want to know if they kept their passport? Well, I don't know if this was what Maria was thinking, but one of the reasons I would think is if the derivative still had their passport and had their approved petition, I mean, there is a possibility you could beg CBP at the port of entry to allow your client to enter without a visa in the passport. There is a real limited possibility that they would do it, but I believe it's a form I-193. CBP does have the ability to waive visa requirements at the port of entry, usually for, you know, serious humanitarian reasons. So that's possible, and having the passport would certainly be helpful because at least they have their identification, they've got their U visa approval, and you can try and get them in before they turn 21 and get an I-94 that says, you know, entered on U status, or at the very least deferred inspection, right? And if you can get deferred inspection, then maybe you can go back and get a full I-94 after a deferred inspection interview. So yes, that's a good point. Asking them whether they kept their passport would be helpful. Let's see. If they enter without a visa in the passport, what would happen down the road with the AOS? That's a super good question. And so the answer would be, if they enter without a visa in their passport, number one, they would have their I-94 card. So the goal here would be not to just enter without inspection and without a visa in their passport. The goal would be to get some kind of allowance by CBP to make a lawful entry into the US prior to their 21st birthday, and for that entry to be considered under the U visa status, I'm sorry, an entry with U status, so it overcomes that requirement that they enter prior to their age out. And so if you got CBP to waive that visa requirement, then down the road at UAOS, you'd have that documented. Yeah, and so good point. Yes, it would have to be documented. Okay, assuming you can't get them humanitarian parole was another suggestion. I think the only trick with the humanitarian parole is, yes, you would be able to bring them in with humanitarian parole, but you would still have to get an admission in U status prior to their 21st birthday, just because of the wording of it. So potentially humanitarian parole. Okay, why do we put this hypothetical up there? And the reason for putting this hypothetical up there is that at the moment, next slide, please. As of March 20th, Department of State has temporarily suspended what they are calling routine visa services at all U.S. embassies and consulates. Embassies and consulates canceled all routine immigrant and non-immigrant visa appointments. As of the moment, and I should say like the moment right now, because they may have changed something while we're on this webinar. So as of the moment, there's no specific date for all embassies and consulates resuming normal services. And so that's why we're talking about this. Would they consider an age out a reason, routine visa services? Or would it be outside a routine visa service and therefore something that they could be able to do?
Hey, Laura, we're getting a couple
Yeah.
questions. Could you clarify what kind of age outs would be relevant for consular processing for UT and VAWA folks?
Okay, so the specific one that I'm thinking of is if you have a U derivative, a child derivative, so a child under the age of 21 and then married of a U principal who is approved but is outside the United States, they must enter the United States prior to their 21st birthday.
You're talking about 929 beneficiaries, right? Because the 929 beneficiaries
yes.
don't have the age out protection.
You're absolutely right. I'm so sorry about that. Yes, 929 beneficiaries, because otherwise it goes by the filing date. I'm sorry, I messed up that hypothetical. Thank you guys for pointing that out in your question as far as the age out. Yes, that's how it affects the age out for in a U situation. Is for the 929, there is no wiggle room, and they must be admitted as a child. In other words, still meet the definition of child, so under the age of 21. Thank you for that clarification.
U3 children would have their age locked in when the principal files the 918, right? Correct.
Yeah, well, we won't get into that. There's a little bit of squirrely language on that. I know we've talked about it. It's outside of this, so let's not talk about that. Let's just say this, read that very carefully, the U3, when the age gets locked in. Okay. So as of March 20th, DOS temporarily suspended their routine visa services. Visa fee that you already paid can be used for a visa appointment in the country where the visa fee was paid within 1 year of the payment. So far, that's what we know. Next slide, please. Embassies and consulates will continue to provide emergency and mission critical visa services as resources allow. So a couple of things there. As resources allow really seems to mean, according to DOS, as resources allow at each particular consulate or embassy. And obviously the reason being that in some countries that perhaps are more harder hit, the consular staff may not be able to, in those situations, even provide emergency or mission critical services. So because it's as resources allow, do check the embassy's website for the country where your client needs to get a visa appointment. So is an age out of a derivative considered an emergency? That's a good question, and I don't know the definitive answer. And the reason I don't know the definitive answer is because the examples given by DOS of an urgent matter include that the visa applicant is an air or sea crew member, that the visa applicant is medical personnel, particularly those working to treat or mitigate the effects of COVID-19. Those were the specific examples that were given for emergency and mission critical visa services. However, they didn't specifically include other emergencies. So, I mean, exclude, sorry, they didn't specifically exclude what may otherwise be an emergency or mission critical visa service. So if you have a situation like an age out that's going to result in you know, permanently being unable to meet that status requirement that they be a child, I would say that is a good situation for you making the argument that it is an emergency. And what I would suggest, in addition to showing, you know, obviously their age, the requirements for that particular, why it's an age out, right? Why it would be an age out in your client's situation. You also may want to include, you know, humanitarian information, right? In addition to aging out, this is what happens to the principal if, you know, their child cannot join them. And I would explain that as well, especially if it's a situation where there is physical or mental health issues to either the principal applicant or the derivative child, you know, what those situations might be. I kind of look at it as similar to evidence that you might submit with a humanitarian parole request, just so they have a few, a real picture that why in your client situation this would be an emergency. Okay, next slide, please. Okay, consular processing of immigrant visas continued. So USCIS is still sending petition approvals to NBC right now. So NBC is still working on immigrant visas. I know that it's been hit or miss getting in touch with NBC. Some people have reported actually being able to get someone on the phone, and others have said it's been radio silence from NBC. But as far as DHS is concerned, right now USCIS is continuing to send petition approvals to NBC, and NBC is still working on them. So during the national emergency, NBC is still creating DOS cases and case ID numbers. They're still issuing fee invoices. They're still collecting documents for consular processing. Why is all of this important? Probably because in some cases, your client is not able to comply with what NBC is still requesting. And so, you know, keeping track of that and having contact with NVC is going to be important. And then also, one thing I would say as a practice pointer, keep track of hardships that your client is experiencing if you are unable to get in touch with NVC when you later, if it's a reason, for example, that you're not able to comply with the 203G 1 year requirement. And you, like, you know, maybe today you can't do it, but also 6 months from now you can't do it. Keeping track of your client's individual hardships and circumstances during this time may be useful down the line if you later have to ask for an exception of this 1 year notice requirement. The other thing I just want to say really briefly here is that right now we actually don't know what the May visa bulletin is going to show. And I mention that because, you know, people are speculating whether retrogression is a potential. In other words, some of this may be moot or cause additional hardships if in May certain priority dates retrogress. And the reason people are speculating this is because of yesterday's proclamation by our president, the executive order that came out yesterday, and we're going to get into that in just a few minutes. So do keep an eye out for the visa bulletin and assess, be ready to assess any cases affected by priority date retrogression, because you're not going to have a whole lot of time. We're already at April 23rd. So if the priority dates are current only through April 30th, obviously some of what you file and want to file, whether you're looking at adjustment of status or consular processing, will be affected after, or could be affected after May 30th, depending on what that visa bulletin shows. So something to keep your eye out on. I'm going to move on to the next slide just because we have several more slides to cover and are getting to within a half hour. Okay. All right. In addition to suspension of consular processing, there has also been the CDC's temporary border entry suspension. So at the northern border at Canada and at our border with Mexico, there's been a suspension based on CDC's authority to suspend entry at the border if it affects public health. So if there's a public health interest, CDC has the authority to suspend entries, or as they put it, CDC ordered the suspension of introduction of persons. So people traveling from Canada and Mexico through land ports of entry who would otherwise be in a situation where, you know, they would congregate, in other words, at the port of entry, where people would all be in a confined space while they get inspected and approved for entry. So this has been suspended, subject to certain exceptions. The initial agreement between US, Mexico, and Canada, based on the CDC's authority, went into effect on March 20th until April 20th. And then I believe it was yesterday, they issued an extension through May 20th. So we have to keep looking and see whether they are going to extend that further. And I will say the materials in your Dropbox link do include the current printout of the initial announcement and also the extension. I tend to print out web pages these days because the policies and the practices are changing so often that, you know, sometimes it seems that clients may later have the need to cite a particular policy as it was when it went into effect on a certain date, and that has now changed, and it's hard sometimes to go back on the website and easily get that. There may be ways to get it through AILA link, et cetera, but or on AILA if you're a member. But anyway, I print them up just as a practice point of view. You may want to do that too. I print them up and save them with a date stamp on it, date stamp from their website. So it shows, on that date it was in effect, and so therefore it was in effect for your client. Okay, next slide, please. So what are the exceptions to these border entries? Here's a whole list. Biggest ones are, it doesn't apply to US citizens or lawful permanent residents, or to the spouses and children of US citizens and lawful permanent residents. Doesn't apply to military, some associated personnel, and their spouses and children. Doesn't apply to persons with valid travel documents who arrive at a port of entry. Now that's an interesting one, and I think that is one where it seems like, okay, that's most people. But it's actually limited in the way that it's applied. Persons under visa waiver program who are not otherwise subject to travel restrictions, in other words, are not from certain countries that are otherwise restricted from entry due to potential public health concerns. And then there's this one: persons whom CBP officers determine should be exempted. I put accepted. I think I meant exempted, but either way, either exception or exemption. Totality of circumstances, based on the totality of circumstances that include a significant law enforcement interest, or a public safety interest, or a humanitarian interest, or a public health interest. So individual CBP officers have a lot of discretion here under this particular exception. So if you do have a serious humanitarian situation for one of your clients, and need, for example, humanitarian parole, make your argument that and present the evidence that in the totality of the circumstances for humanitarian interest, they should be allowed at the port of entry. Okay, and so someone asked, when you say valid travel documents, can you please clarify tourist visa holders are not allowed to enter? I have heard reports that tourist visa holders, in fact, being removed at the border. So yeah, that's a good point. So that was kind of my point in going back where it says valid travel documents who arrive at the port of entry. You're right. So let's say an H-1B visa holder may be allowed to come in, but the normal flow of border crossers, just general visitor visa holders, or in Canada, they're visa exempt, so it may be just, entering for a visit. You're right, they will usually be turned away. However, that last exception to the rule of the CBP officer having the determination in the totality of the circumstances, blah, blah, blah. We've also heard of people being allowed to enter on visitor visas if they can also meet this totality of the circumstances requirement. So yes, thank you for that question and for going back to that. Okay, super important point about this is that this can be continued to be extended. The requirement is is that CDC show it's necessary to protect the public health. Unfortunately, there's a lot that's being done to immigration in the under the guise of necessary for the public health. So right now it's extended through May 20th. Keep your eye out. This is likely to get extended again. Well, I don't know. That's my personal opinion, is that it is likely to be extended again. I shouldn't say that as if it's fact. It's not fact. It's just supposition. Okay, next slide, please. All right, and that takes us to yesterday's order. Since you know, a full assessment of yesterday's executive order and what that's actually going to mean is still being evaluated by all sorts of organizations, including our own. I will just start this section with a caveat that we will expand this as it relates to its effects on survivors in the coming days and weeks as we learn more. But for now, here's the summary of what happened with yesterday's executive order. What the executive order does is it restricts entry for 60 days of certain immigrants. So this is relating to entry. Should not affect people who have already made an entry. The only thing I'm going to say here is that if you have someone who was given deferred inspection, that may not be officially an entry. So please do get that person inspected as soon as you can. And that's just, again, we will continue to like look at this more closely, but that's the kind of the first thing that jumped out at me. Okay, so restricts entry for 60 days of certain immigrants who, number one, are outside of the United States and do not have an immigrant visa that is valid as of 11:59 p.m. Eastern today, and do not have an official travel document other than a visa. So in other words, if they don't have a visa and they are outside of the United States, they don't have a travel document, an official travel document, and they're outside of the United States, this will affect them for the next 60 days. And again, same thing for the visa and for the travel documents that are mentioned here. Valid as of 11:59 p.m. Eastern on April 23rd, so today, or issued on any date after that, right? Why do they include that? And they include that because as it is, consular services are already limited, right? We just talked about how consular services are limited. So if you got past consular services and they actually approved your visa, well, then you've already shown them that there was some emergent reason for you needing that visa. And so therefore this, you should be exempted from this executive order as well, or at least that's how we're reading it. Next slide, please. Who is also, so who is exempt? So exempt from this are persons who are lawful permanent residents already, spouses and children under 21 of US citizens, including prospective adoptees, members of the military and their spouses and children, certain medical healthcare professionals seeking to assist. It's really, I included this language because the language here in the executive order is more specific than the language in the CDC order and is more specific than the language in the DOS guidance on the restricted consular visa issuances, I should say. So look at the language here if you have someone in that situation. It also exempts employment-based immigrant investors and Afghan or Iraqi interpreters or others who have worked for the US government. So that kind of leaves a little bit of an opening there. Next slide, please. And then there's this general exemption. The others who are exempt are others designated by the Department of State and the Department of Homeland Security, whose entry is in the national interest or whose entry would further important law enforcement objectives in the United States. Okay, so that's an important caveat because questions that come to mind immediately are for law enforcement objectives, does that include a U visa, permanent resident? Thank you. That's the word I was looking for. Permanent resident applicant, where the principal U is here in the United States, still working with law enforcement and they need their family member to come in as immigrants to support them, to help them, to be there for them. We don't know, but I'd make the argument, right? I'd make the argument that the I-192 family member perhaps could fall into this exemption if they're assisting law enforcement. Or the other possibility in terms of survivors is, what if you have a VAWA self-petitioner who has a pending charges against the abuser and must, get the visa issued, come back to the United States to help law enforcement by testifying against the abuser or whatever the case may be. Those are two that kind of popped up. Now we have to, continue looking at this further to see what other ways it might affect survivors who are outside the United States. Next slide, please. Oh, sorry. The final thing I will say about that is, before we get into detention and stays, the final thing I will say is look at Section 6 of the executive order. There is a big question mark there as to the expansion of this order, as the president has asked, or required, I should say, Department of Homeland Security and Department of State to let him know what other visa, immigrant or non-immigrant, changes should be made to protect, basically to protect U.S. interests, and very, very general language in this particular section, which is worrisome because perhaps it will expand further and will affect our survivors further. So we do have to move on, so I'm going to go ahead and move on, but if you have questions on that, ask it in the chat box. Thank you.
All right, so the next topic is detention and stays. We have somewhat limited time remaining to us, so I'm going to go relatively quickly here, and if you guys have questions that you want to address that we're not able to get to, please submit a TA about this. I'm actually going to skip this poll as well, just in the interest of time. I know that some folks are going to have a lot of detained clients, other folks aren't going to have as many, but we just wanted to make sure that everybody is aware of some of the issues that are coming up for ICE detainees in light of the COVID epidemic, and some strategies that other practitioners have taken to protect their clients. Obviously, we know that detainees, anybody who is institutionalized or incarcerated at this time, is especially vulnerable to COVID-19 because of the very tight quarters, the lack of proper sanitation, the underlying health issues that a lot of detainees already have that put them at higher risk. And so obviously we're talking about a very vulnerable population here. And so the first thing I wanted to flag for everybody's attention is a class action in Freiheit v. ICE. It's actually a long-standing case, but as part of the COVID epidemic, they filed a motion for preliminary class certification, which was just granted. And so the two classes are ICE detainees with risk factors, placing them at heightened risk of severe illness and death, and also those who have disabilities that put them at the same risk. And the order, which is in your Dropbox materials, has the specific description of what is considered a risk factor covered under this class, as well as which disabilities are covered. And preliminary class certification was granted in this case. A TRO was granted in this case, under which, among many other things, ICE needs to make a timely custody determination for detainees with these risk factors and disabilities. And I think one thing that's really important to note here is that the description of risk factors and disabilities that are covered under these classes go well beyond the list of risk factors that's on the CDC website. It includes people who are younger than what the CDC says. So the CDC says people over 65. The risk factors include people over 55. It includes people with severe psychiatric illnesses, and lots of other things that are not necessarily on the CDC website. And so I would encourage folks who have clients who are detained to take a look at this case and really do a deep dive with their clients to figure out whether or not any of these additional risk factors and disabilities apply in those cases. Because if they do, then under this TRO, ICE has to make a custody determination for them. And so we would encourage folks to file or reiterate their parole requests for these detained clients with ICE under this Freihat case. Next slide, please. In addition, ICE has issued its own guidance on detained docket reviews in light of COVID for detainees. Obviously, it doesn't go nearly as far as what the judge ordered in the Freihat case, but at a minimum, ERO is required to review custody for certain high-risk groups. And so ICE has a much narrower list of what is considered high risk, but they do include people who are pregnant or delivered in the last 2 weeks, people over 60, and people with certain chronic illnesses that could put them at higher risk of severe illness if they were to contract COVID-19. However, even if ICE does find that one of these factors does apply to a detainee, under this guidance, they're not required to release that person. It's just considered a significant discretionary factor. But when you're making your parole request, we would suggest including references to this guidance as well, which is also in your Dropbox materials. Next slide, please. And then, of course, the typical parole considerations apply for now, just as they did before, right? So detainees could apply for parole from detention under either 212D5 or 236A2B. And so they would want to show that they're not a flight risk, not a security risk, and then urgent humanitarian reasons are potentially something that would especially apply in this situation, right? So if your client has other serious medical conditions, and for this, it doesn't necessarily, it doesn't have a specific list of what's considered a serious medical condition. This is something where, as we'll be talking about later, in some cases, people have been able to effectively argue that all sorts of medical conditions that their clients have that are not necessarily on any of these specific lists would potentially put them at increased risk of severe illness if exposed. And so we suggest if your clients are detained that you file parole applications, making arguments under all of these provisions, the class action, the ICE guidance, as well as the normal parole provisions, and making sure to document any medical conditions that your clients have, and of course the other considerations as well that you normally would include anyway in a parole application. Next slide, please. Okay. And if ICE refuses to release your client, then you still have federal litigation options available to you. And there have been a lot of cases lately. These are just a few that are in your Dropbox materials. Folks have been filing habeas petitions and TROs in order to obtain the immediate release of their detained clients. I would say that most of the cases that I've seen have involved detainees who do have some kind of underlying medical condition, whether or not it is specifically on the CDC guidance. There are certainly folks who've tried for clients who don't have underlying medical conditions. Those cases seem to be a little bit more difficult to win, but still definitely worth a shot. And so just as an example of what folks have been able to do, there was an SDNY case. All of the plaintiffs in that case did have underlying conditions, including asthma and other things like that. There was another case, Fofana, where it was another group of plaintiffs, and the judge did order the immediate release of one of them who was 52 and had high blood pressure, but then there were an assortment of younger plaintiffs who didn't have health conditions, and the TRO was denied for those individuals. But then there was another case in the Northern District of California where it was a young detainee with PTSD and depression, and the judge did look closely at the impact or the potential impact of his latent TB on his risk for infection or severe illness. And of course, as you guys know from doing medical exams for your adjustment applicants, there are a lot of foreign nationals who do have latent TB. And so it's something to explore with your client, just to see if there are other conditions that would make their likelihood of getting a release on this habeas and TRO strategy more likely. Okay. Next slide, please. Okay. In addition, so as we said earlier, ICE has said that they are relaxing their posture on immigration enforcement during the coronavirus epidemic. They have said that they would focus on people who are subject to mandatory detention due to criminal history, as well as people who pose a security risk. In theory, this means that other folks should feel safer, but we don't actually know, right? We don't actually know how this is going to play out. And so it's always better to be safe than sorry, right? And so what we've been recommending, what we continue to recommend, is that if you have a client who is post-order, if they're detained, then we would recommend filing a parole request and or a habeas TRO suit in federal court. If they're non-detained, then we would still recommend filing or at least preparing a request for stay so that you have it in case the client is picked up for any reason. Clients shouldn't be required to check in right now. They shouldn't have house visits either at the moment. Those should be suspended, but depending on the office, you might have clients who are required to do telephonic check-ins or things might vary a bit. So we recommend preparing the stay just in case. There are all of the usual stay arguments that everybody should be making, including, you know, caring for dependents in the United States, hardship to the client if removed, if they have a pending U visa petition, then certainly including that and making your arguments with respect to why I shouldn't be removing people with a pending U visa petition who cooperated with law enforcement pursuant to the August 2019 U visa stay memo, as well as the prior memos from 2009 on stays for U petitioners. So all of those typical stay arguments still apply, but in addition, we would also recommend including evidence about COVID-related hardships. So for example, does your client have any particular risk factors? Are they caring for dependents who are sick or who also have other risk factors who might be at increased risk if your client were returned? To the extent that you have those factors, obviously you want to document those, preferably with medical records and things like that. You can also take a look at the conditions in the country of origin to which your country would be removed. What are the measures that the government in that country has taken regarding COVID? Are the airports even open, right? There might be some logistical reasons why it would be difficult to return your client at that point. And then the other thing is that with respect to the ICE flights, so the flights that ICE uses to return folks, they are supposed to be screening everybody before they get on the plane to see if they are able to fly without exposing everybody else on the plane. So, maybe flagging if your client has known COVID exposure or recent illness or is ill or something like that might dissuade ICE from trying to remove your client at the present moment. Next slide, please. All right. And as usual, these stays are discretionary, so there are lots of things that would be good to include to make the case for discretion, including victimization, certainly, evidence of the pending U or T visa petition, particularly if it's a T, because T principal petitioners would lose eligibility if removed. We would really highlight that fact. And then the needs of the client and family members and all of the typical issues that people should be raising in their stay applications. Next, please. Okay. And if your client with a pending U visa is facing imminent removal, so we would recommend if your client has not actually filed their U visa petition, please do so immediately because that is potentially going to give you additional avenues for making the argument against the actual removal. If USCIS feels the need to issue an RFE, so with respect to the prima facie determinations, as of the August 2019 memo that came out from ICE, they say that they have gotten rid of the prima facie system for U visas. At the same time, we know that USCIS will continue to expedite applications, especially at the request of ICE and other agencies. And so if you can go ahead and file that U visa as soon as possible, you can try to get that U visa expedited. It's potentially going to be more difficult for you to argue against the removal if ICE is saying that your client is actually not eligible for the U visa, obviously. So you want to make sure that petition is complete. You should, even though ICE has put out this fact sheet on the new ICE use stay guidelines, we still recommend asking ICE to request that prima facie determination from Vermont Service Center in addition to the expedite request, just because ICE has never actually issued formally the underlying guidance behind that fact sheet. We do actually have a copy of it that was obtained through a FOIA, that was submitted as part of a complaint, but ICE itself has not actually released that documentation. And so our position is that unless they actually release it themselves, they haven't officially renounced that policy or rescinded that policy, sorry. In addition, file the ICE stay. If there's an argument for a motion to reopen with EOIR, then file that as well. Some, depending on the basis for the motion, it might come with an automatic stay, which should obviously defer removal. And if it doesn't come with an automatic stay, then you should file a motion for stay as well. And then at the same time, contact us, contact the USCIS Ombudsman, contact the client's congressperson for assistance, because we may be able to provide additional assistance on these types of cases. Next slide, please. I think that actually brings us to our conclusion. Yes, so things are changing day by day. And we don't know necessarily from day to day what else is going to come out from USCIS. They could be extending the office closures. They could be responding to the requests that we've made for deadline extensions. We have no idea, right? And so USCIS has its own news site where they post all of their updates with respect to their policy and processing. So I would recommend keeping tabs on that. ICE has its own coronavirus webpage where they should be posting their updates. And we've tried to gather various updates, including resources for practitioners in terms of practice management and working with clients during the epidemic and figuring out how to work remotely and get the things that used to be so easy to obtain and are not anymore, as well as our other guidance documents. Next slide, please. Okay, so thank you so much for bearing with us. And you can feel free to contact us for individual assistance. I know that there were a lot of questions that we were not able to get to in this time, so please feel free to submit a TA, and we're happy to get back to you and work with you individually. You can also see all of our practice advisories on the link at that URL right there. I am seeing a question, are the materials available anywhere other than Dropbox? Right now, they are only available in Dropbox. So we generally do it that way just because the size of the files can make it difficult sometimes to email. If you have a particular difficulty accessing Dropbox, let us know and we'll try to work with you and make sure you have access to the materials. All right. So Laura, was there anything else that you wanted to add?
No, I think you covered it. And even though you said you were going to go fast and may not get to everything, you got through everything. So, and right on time too. So, you all as well. And just as Amy said, feel free to send us technical assistance if you have additional questions. Have a great rest of your day.
Thanks, everybody. Stay safe.